I'm bringing the April. I'd like to bring the April 25th, 2017 meeting of the Complaint Committee of the Sunshine Ordinance Task Force to order. Please call the roll.
On the call of the roll, Member Wolf.
Here.
Wolf present. Member Hinsey.
Present.
Hinsey present. Chair Tesfa.
Present.
Tesfa present. We have a quorum. There are no agenda changes that I know of.
Can we move to item number 2?
Item number 2, approval of the March 28, 2017 Complaint Committee meeting minutes.
Move the minutes.
Second. We can take that by acclamation.
Public comment.
Oh, do we have any public comment on the minutes of March 28th, 2017? Seeing none?
I assume that that is approved without objection.
Yes.
Thank you. Next on the agenda, item number 3, public comment. Members of the public may address the committee on matters within the committee's jurisdiction, but not on today's agenda.
Should I read this again? Yes. Kate Patterson is the Public Information Officer of the Arts Commission, who's been slandering and personally attacking me at Sunshine hearings for over 5 years. She makes false claims as to why she refuses to turn over responsive documents, even in their redacted form. Her claims have included, I spent time in prison, I have false names, stalking and harassing people I don't know, and I've been arrested for selling bottle caps. I've done none of this. There's never been a San Francisco police report on me, and this cannot be an ongoing police investigation, because without a police report, there could be no investigation. Any investigation by the city attorney's office is not subject to Sunshine. Patterson's unsolicited email to me of April 10th this year makes additional claims of perceived harassment via email. I'm not sure what she means by perceived, and I'm not the only person who doesn't understand what she's saying or why she sends these type of emails. But I would like her continued reason for not turning over documents based on slander to stop.
Thank you. Do we have any other public comment? Seeing none, let's move to item number 4.
Next on the agenda, item number 4, file number 17016, complaint filed by Jerry Dratler against Ben Rosenfield and the Office of the Controller for allegedly violating Administrative Code Section 67.21 by failing to respond to a request for public records in a timely and or complete manner. This matter was continued from the last meeting of the Complaint Committee. The committee has previously found jurisdiction on the matter.
Can the complainant please approach? Or petitioner?
Thank you.
And we have one of our other members present this evening who wasn't present last time. So if you could give a brief summary. I have a couple of follow-up questions, but just so that we can bring us to today.
Thank you for the opportunity. Mr. Rosenfield's initial response to my Sunshine request was to say the requested documents are protected documents. He is claiming the CSA audit memorandum are, in fact, audit reports, and the Cumming, which was the outside auditor, audit reports are CSA audit work papers. This makes no sense because the CSA titled their first 2 audit summaries memorandum. Also, it does not make sense for the CSA to classify their memorandum an audit report when they performed none of the activities associated with an audit. I'm a CPA, I would understand that. Their document is a summary of the audit report. I provided arguments why the CSA memorandums are memorandums in my response. I won't go into that. Basically, they're that. But I think the most compelling one is on page 10 of a Cumming presentation to the Citizens General Obligation Bond Oversight Committee, where they classified or presented the deliverables. They said they would do an audit report and audit work papers, and the CSA was to deliver audit memorandum. So I wouldn't argue with their categorization. I'm contending the real motivation for Mr. Rosenfield not wanting to release the coming audit reports is there are adverse audit findings, which I presented in my response, and his office wants them buried, and his process for burying the adverse audit findings is to issue a summary report and claim it's an audit. That's it.
Okay. Can we hear again from the respondent, or do you have a statement? Thank you.
Tanya Ladishu, Control. As discussed last week, we have provided Mr. Dratler with everything that we have. Cummings is an arm to the City Services Auditor, which I have the ability to bring in a contractor to assist me to do audit work. If, as we explained, according to the Yellow Book standards in which we use, we have the right to issue our reports in the format that we choose. In this case, we called it a memorandum. It clearly defines and reports the findings as such. There are no adverse findings that we're hiding. All documentation has been presented fully as required by our Yellow Book standards. And in order for me to stay in compliance with Yellow Book standards, I need to ensure that I adhere to those standards. And we have every year under my leadership passed our peer review, and we're getting ready to go through one this coming May, June, and we shall pass that one as well. And so again, this office has no reason to hide any findings or recommendations. And in fact, in the work that has been done by Cummings, there are no exceptions noted. And anything that has been noted, we've made sure that it's there. Thank you.
Thank you.
And really quickly, I'd like to add, we actually sat down last week with Mr. Dratler, and we went over every single document that we have fully. And while I don't disagree that he's a CPA and understands accounting, we are following government auditing standards. And I have spent over 25 years in leadership as a government auditor very successfully.
Thank you. Can the petitioner approach the microphone? I have some questions.
Thank you.
So last time that we heard your complaint, you had shown us a few documents that weren't in the record. Are they in the record at this time?
Yes.
Can you identify the pages for us?
They're actually the documents that the Controller's Office provided, which are the detailed audit reports. They're quite large.
Okay, but if you could just identify where they are in the record. So the issue last time was that we were trying to find out how you knew that there was a final version different from the draft version, and you were able to show us a copy of the draft report in your hand and show that that draft report didn't correlate to what the final memo that was posted.
That's correct.
So what I was requesting was for you to provide the draft report in the records so that we would have something that we could rely on. And if you could just identify the page number for us.
Certainly.
And then if you could also identify the memo that you were saying does not correspond. Because what we're looking for here is that this document would exist. And so you were able to show us that there was a draft copy of the report and that there was a final copy of a memo. But we didn't actually see the draft report, so there was no way for us to compare it to the final memo and show that it wasn't.
On page 13, well, it starts
The respondent's, the complainant's additional response begins on page 31. Mm-hmm. Okay. And the respondent's most recent response is on page 61. And that is the large printout.
Right. So I'm trying to compare the document that starts on page 31. So this is the draft.
Right, that's my response. So on page 8 of my response, which is on your
Our page 38.
Your page 38, thank you very much. the preliminary findings, and there were 33 of them. I excerpted one, which said the Hall of Justice planning cost, page 7 of the draft audit report, shows there are $2.2 million of planning expenditures, where the scope of the actual expenditures is unclear and the amount of actual expenditures is unknown.
Right. No, I was asking for where is the draft report, not a reference to the draft report.
This
Last
is
time
the-
you had a document in your hand that you said this is the draft report.
draft report.
And it begins on page 31, because just the top of 31
No,
has...
that's my response. I'm sorry. Could you tell me again where the audit reports are that the controller's office sent?
That begins on page 61.
Okay, so on page 71 is Exhibit 2 that was provided by the controller's office.
Does it start with executive summary,
Yes.
Exhibit 2?
Yep. And that goes a long way. So these are the draft audit reports, and you can see they're very voluminous.
So you said page 71 where it starts executive summary? And so this is the draft audit report.
Yes, well, this is Exhibit 2, which is the draft audit report. And then
It
on
says-
page 79,
It says final report, Exhibit 2, final report.
yeah, what's interesting about that,
And it's signed. It's initialed.
what's interesting about that is the copy that I was provided is doesn't have a final date. It has 2 X's. It has June 2016, and this is the 2011 road repaving and street safety bond expenditure performance audit, June 1, 2016.
So is that document in the packet? That is what I
Tanya?
believe that you held up
Yeah.
last time,
This is-
but I asked you to include it in the packet so we could rely on it.
That's Exhibit 2.
He's not on the clock. He's answering my questions.
That's, because Exhibit 3 is the earthquake safety bond. So let me just, 1 second. I
As you're
appreciate
looking,
your patience.
I'm just going to discuss or explain what I'm trying to get at here. Last time we were here, the petitioner said, this is a draft report. He held it up, and he said, all I have received as the final report is actually a final memo from the city, not a final audit. And I was trying to find out how he knew that there was a final audit or that that wasn't the final audit. And he said, well, that's because I have a draft version of it. And it doesn't look at all like this memo. So it's obviously not the final audit. It's a memo based on the final audit. And so I would find it difficult to say that there was a violation of the Sunshine Ordinance if we don't know that a document exists. So by him being able to produce this draft report or the draft audit, that would make us, some evidence to show that a final audit exists beyond just a memo about the final audit.
Okay.
And so I'm still looking to see where is that draft audit, because you held it up, but
Page 120, I'm sorry.
okay.
So that's the 2011 road repaving and street safety bond. And it's titled an expenditure performance audit.
So that was the draft that you produced the last time?
Yes, sir. It's just like this.
So page 120, and it says page 1 at the bottom. So where does it say here that it's the draft? Just to make sure it's the same thing that was in your hand.
Thank you. So there's a, well, this doesn't have it, but let's just go. So on mine copy, there's a memorandum. One second, please. So there are two documents that I have that, Tanya, are these two in here? The memo to Julie Dawson, DPW, and they are exhibits. Okay, I didn't want to duplicate, and just make the binder bigger when Tanya sent them, so, all right. So.
Okay, I just show me where it is, because I asked you to send them, not Tanya. So
I'm sorry. She sent them first, and I figured it would be duplication. That was an error on my part. I apologize for that.
Actually, duplication is preferred because sometimes there's discrepancy between one party sends what another party sends.
What is the draft?
Okay, I'm new to this, so I apologize. So you can see I've gone from page 116 to page 250. So that's why I didn't send it. Now I'm on road repaving and street safety bond. Again, this is a little confusing. One second. So we have we have two documents here. If you look at page 120, it says 2011 road repaving and street safety bond.
Are you referring to the page numbers in our packet?
Yes, I am.
Okay.
And then if you jump ahead to page 257, it's also titled, but it has a different title page. And this is the one I had.
Page 157?
257.
Oh, 257, I'm sorry.
So you can see it's a little confusing here. So you have
one of the documents is at 257, and what document are you saying this is?
Oh, but wait a minute. 250, the one page on 120 is Appendix A. This one says Appendix B.
right. And what's interesting about this is I never got any of these documents. I got the audit, but without the appendices.
But
So
page 120 is an appendix. So what about the
Audit.
everything prior to the appendix? The actual report itself. Is
Okay.
that prior to 120? Page 120.
Okay, that's a very good point. I never got Appendix A or B, even though I asked for the complete report. So you're right. No, this is,
So let's ask the controller.
yes, please.
So the documents that we see in here are just the appendices. Where's the actual report? I think that's the question that we're getting at here. I'm sorry if I'm speaking out of turn, Madam Chair.
Well, it's just last time he held up a draft report. I'm trying to see, and I asked him to put it to submit it and put it in the record. Trying to figure out where that is. Seeing the draft report, would help us even think that a final report exists. Right now, I feel like a final report does not exist, and that you're requesting something that does not exist. That the city has given you everything. We need to be able to see, like, you say that you had a draft report. We need to know that you had that. We need to see that draft report in order to order the city to produce the final version of that.
I appreciate that. I'm sorry about the confusion
Okay.
on my part.
So if you look at your page 71, just as an example, and that page 71 through page 77 is one complete report of the road repaving and street safety. This report is online, and it has the appendix that page A1, which is an attachment of the department's response to the work done. So that we provided that link to Mr. Dratler when we issued that report, because it's on our public website. So that's what that is. So in fact, those appendices were received. They're online.
Thank you.
So, can I speak?
Oh, okay.
I'm a
Do you
little
have- do you have any
confused because there are hundreds of pages in appendices A and B. So could you clarify, when you say appendices, which appendices you're talking about? Because I didn't get those hundreds of pages, even though I asked for the full report. And that was, it was obvious in the title page of the report that there was an appendix there.
Do you think you clicked the link in the documents?
I tried.
Sometimes it takes, a few minutes if it's a large document to open.
But it's Cummings' site, and it's a protected site. It's not on the controller's site.
Oh,
No. If you go to our site today,
it's on
I
there.
can guarantee you it is there with no mistakes.
But was it then?
The hundreds of pages?
It was then, because when we send out our reports,
All
we
the
send our link and we send it to the Board of Supervisors.
All the links say sfcontroller.org.
Yes.
Yeah.
Okay, all right.
We would never give you our contractors. Our contractor is an invisible arm to my organization.
Okay.
Right, but as was pointed out by one of the members here, on the
In
title.
the
Can we have
microphone.
one person
There's a
at the
link.
microphone so we can get them?
Yeah, I'm in
Okay.
the microphone.
Okay, on the title page, as one of the members pointed out, there's a link and it says appendices and it has a path. That's not your path, is it?
Which
What page?
which item are you showing us? Yeah, Mr. Dratler. Because the ones that I'm seeing say sfcontroller.org, and then the path means
Right,
it comes from
but the-
sfcontroller.org.
Mr. Wolf's question was, this looks like an appendix, and that page he was looking at is not a link to the CSA.
So, Mr. Wolf, could you direct me to the page that you're looking at, please, sir?
Oh, I don't have that.
I think it was that 257.
257.
I moved away
It was
from it. So hold on.
251.
It is 257.
Yeah, right. I tried to download that link.
That wasn't for you to download. We gave you this as coming supporting work paper documentation. You won't have access to that, nor will anyone else have access to that.
Right. So I think
But it's on a public document.
So please understand, because we have a major confusion about this work that I continue to really try to explain. This contractor, this professional contractor, is providing professional services on my behalf. The work belongs to me. It does not belong to the contractor,
You personally?
to the controller's office.
So that's everything that's contracted by the city, work product that's produced by that contractor belongs to the city.
Exactly.
So it's public information?
I'm not refuting that.
Oh, okay.
I'm not refuting that at all, sir.
Got it.
What I'm saying is they work in my organization as auditors on my behalf. all that work is remitted to me. I have control from the city perspective as a city officer. I control that work. That work has to be remitted to me. I take that work. It goes through a review process that's required by my standards to make sure that all the facts are correct before I finish going back out to the department to get their final response to put on and then publish on our website. The final document that was produced comes from my office legally and by standards. I have the authority to do that, to hire individuals who might have special expertise that work alongside myself and my staff. I took that information, I compiled it appropriately according to audit standards, and then I released that. It was requested by Mr. Dratler. I provided that information. And I believe what we're really arguing over more than anything is the word memorandum and final audit report. There's nowhere in my standards that prohibit me from saying using a memorandum or the word final audit report. And while again, I respect that he's a CPA and he does financial audits. I'm doing my work according to standards, and I have not violated that.
So I think if we just focus on this one page, it'll bring clarity to the discussion. So Cummings, yes, who's a contractor of the city. A fine point is the CSA is overseen by the Citizens Journal Obligation Bond Oversight Committee, and they actually requested this report. So the CSA managed the engagement, but it's ultimately not the client. So the other point here is Cumming labeled it, correctly so, an expenditures performance audit. So this is an audit document. Now, it's an audit document. I was given a copy of this audit document. The copy I received was a draft copy.
Where is that? I need to see a document that says draft in order for me to say that a final version of it exists somewhere and is not being given to you.
Okay. Again, I erred because when I saw the PDFs and I saw them stamped, Exhibit 1, Exhibit 2, I didn't think I needed to do that. But the letter...
Well, let me just ask then, did the document that you received that you claim is a draft, did it say the word draft on it?
What was interesting is if you read...
It's just a yes or no question.
Yes, it did. It said draft audit report, and that's really why I did the sunshine request, because unless the auditor resigns, you get a final report, you don't get a draft.
Thank you. Yeah, and we want to help. And I think the best way for us to be able to make a recommendation to bring this to the full task force is we need to see that there was a draft report that you said was in your possession. It has to be in the record in the public packet that Victor distributes.
I'll do that definitely.
Okay, so then what I would like to do at this time, we can discuss it now, is I'd rather continue this to our next complaint committee meeting so that we can have all of the facts, physical facts in the packet in order to make a recommendation.
I'd like to suggest something else. I'd like to suggest that, there's still time before the next, there's still time before the next meeting. Next meeting is next...
May 23rd.
May 23rd?
No, the next task, the full task
Should be
force.
the first week
That would
of
be
May.
next week on Wednesday. That would be May 3rd.
So 5 days prior is our usual standard. If he provides it 5 days prior, if you're satisfied that that would find the violation, then that could be presented to the task force, and it could be was this scheduled for the upcoming meeting?
It is not at this time.
It's not. Okay. So all I'm saying is to dispense with this quickly.
I'm concerned that we will not dispense with it quickly, and we'll be there all night.
Okay.
Because we won't have the facts. We really...
Okay. Very well.
I would feel more comfortable using the full task force time on a case that has all of the facts presented.
Fair enough.
No,
At your pleasure. It's fine.
Okay.
I totally support that. The one thing I would like to add is that the what I believe is an arbitrary distinction. So if if this is an audit report, why am I not entitled to Appendix B? It's a city document.
Maybe the city can respond to that.
Well, wait a minute. Your original complaint did not include
Right.
that, so we can really only adjudicate based upon what your complaint is exactly for. If you want to extend that,
That's my question. So if we're going to extend this a month, I'd like to issue another sunshine request for Appendix B so we can deal with the whole basket of questions.
if that's the case, then I would say if he does that, wait for it to be processed, comes to the complaint committee, combine them.
Okay. So at that time, we will combine your two complaints so that we can dispense of the matter.
Right. Do you have anything to say?
We've heard you've given everything you have, so.
I don't have anything else to say.
Okay.
So it's my assumption that we will be expecting a new complaint to be submitted by the complainant?
Yes, and if you can schedule them on the same day so that we can combine them.
Yes.
And the documents, I'll produce them immediately.
Yes, please.
Thank you.
And Victor, if you can include those documents in the packet, as you always do.
Thank you for your time. Sorry.
course.
for the confusion.
Just real quickly, do I need to resubmit anything for that particular hearing?
I don't think so. If you're claiming that the final report or memorandum
Sure.
is complete and included currently in the record,
Okay.
then I don't think there's anything more.
Well, I would like to add to that. What if he's submitting a new sunshine request for Appendix B?
Oh, then, okay.
Then you should respond by producing that,
Or whatever he's going to request.
or whatever he's going to
yeah.
request. Produce what you have on that, and if he says it's incomplete, then he can file a complaint here for us to.
Okay. Thank you.
Thank you.
Have a good evening.
Thank you.
I'll make a motion at this time to continue this matter to the next meeting of the complaint committee.
Second.
Do we have any public comment on that motion? Seeing none, if we can call the roll, yes.
On the motion to continue the matter to the next meeting, Member Wolf.
Aye.
Wolf, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye, thank you.
Tesfa, aye. The motion passes. Next on the agenda, item number 5, file number 17017, complaint filed by Dolores Clean against Randy Quezada and the Department of Homelessness and Supportive Housing for allegedly violating Administrative Code Section 67.21 by failing to respond to a request for public records in a timely and/or complete manner.
Hi, yeah,
Jurisdiction or at your discretion? You
Yeah.
don't have to do it immediately.
I'd like to make a motion I'd like to wait on the motion to find jurisdiction and kind of hear which agencies are involved, and so we can determine if we have jurisdiction over them. Please introduce yourself.
yeah, Dolores
Can you pull the microphone over?
is a Twitter pseudonym, or, it's commonly used to use other names on Twitter, and that's something I've been using since 2010, like 7 years, and I have like...
So that's you?
That's me, yeah.
Okay.
And so kind of like the facts on it, it's kind of, I got Twitter blocked by the director of the homeless serving services after commenting on homeless services, and he's always puts out tweets about it. So in some way, it's kind of like a First Amendment type thing that I'm trying to do, because it was based on the content of that they blocked me and didn't let me get the seat. But since bringing a whole First Amendment case is so expensive and all, this seems like a way, and it is also a public records violation. So should I go the theory or the facts first?
Victor will give you 3 minutes to give you the facts of your case, and also if you could specifically explain why you think this is a violation of Section 67.21 of the Sunshine Ordinance.
Okay, you might have to help me out with just what that is.
Would
But
you
let me
like
do the
to-
facts then.
Would you like me to reset the clock at this time?
Yes, please.
Okay, so Jeff Kaczynski is the director of homeless services. He uses Twitter all the time to do tweets about homeless services. He's gone out and blocks accounts that are critical and asks questions about what he does. when he did that, he referred to my responses as both hate and hyperbole, and also said that he's interested in opinions that respond to all occurrence, which also has legal significance. After I sent a tweet to him, which I included in the record, and asked to use the link because it's kind of a video in that it's a slideshow of like 8 or 9 pictures. He went, and I asked him after a public question, you said all your work is done in the mission, but look at all of these problems that still exist, and it's really cold out there. And he responded to me, but then after that, he gets blocked, and he starts blocking other people. And there at the meeting, he says, like, George Bush on the Abraham Lincoln mission completed. We're done in the mission. Under the guidance of the city attorney for several years, tweets are public records. And then most recently, in a case, City of San Jose, the California Supreme Court confirmed that they are, and that is the longstanding advice. It's also now going on sort of with the U.S. Supreme Court. Justice Kagan says, we know that Trump tweets, every single senator, every single House of Representatives has it. It's kind of the same thing here in San Francisco. These are public records. And then he's gone out there and deleted them. I took one of them, was able to have a screenshot of it. The other one you can see by the sequence of it that it's talking about, which was the tweet where he responded, in effect, saying, I didn't say that at the public meeting. And then later on, the tweet about that gets deleted. And then the second tweet that he's deleted is no longer out there is the one about where he says, hate and hyperbole. That's why I'm blocking you. But that the significance of the other part of his statement that I'm interested in these, it goes from a case that in effect says if they invite a public forum, whether they have to or not, once they do it, they cannot use content-based restrictions to block someone out and kick them to the curb. And that's most recently in a district court case in East Virginia and citing to a Supreme Court case, Rosenberg. I see my two seconds. So.
Thank you. Is the respondent present? That would be Randy Quezada of the Department of Homelessness and Supportive Housing. Please approach. Victor, can you give the respondent 3 minutes, please? Thank you.
Good evening. My name is Randy Quesada. I am the Public Information Officer for the Department of Homelessness and Supportive Services. On March 7th, we received a request for copies of all tweets by Director Kaczynski of our department that are relevant to the issues of homelessness, homeless services, encampments, sweeps, etc., beginning July 1st, 2015, until the sunshine was fulfilled. We are a new department. The department was launched and created last year. Admittedly, the response was late. This was a sort of a new area, a new ground for the department, firstly in how to respond to sunshine requests, and then sunshine requests of this nature. This, again, is new territory. Copies of tweets are rather ephemeral. They exist online with anyone has access to it. So we were late in getting back to Mr. Clean about needing more time to figure out how to do this. In due time, on the 24th, we did provide Mr. Clean with access to all of the tweets. He is able to access them through going onto the Twitter website. All of the tweets are there. They're publicly available, so he always had access to them. The fact that he is suggesting that he couldn't access them because he was blocked is incorrect. You can sort of log out of Twitter and then see them, which we also noted. So I'm not sure what else we can do. In the end, Mr. Clean was unblocked as a courtesy, but still, I'm not sure if that was sufficient to meet Mr. Clean's request. I'm not sure what else we can do. He has been unblocked. He has access to the tweets. Anyone else who has been blocked and perhaps has not requested access to the tweets can similarly see them if they are logged out of Twitter. They can see them.
Anything else?
No.
Thanks. Okay, we need to make a motion to find jurisdiction. On that topic, I know that right now we're looking under just 67.21. I just want to clarify that's what we're looking at. Do we have a motion to find jurisdiction?
So moved.
Second.
Okay.
So I just want to state for this is there are really two litmuses here for me. One is it within our jurisdiction to hear this case? And I think it is because it's a city department. And then the second question is the information being requested public. And I think that's really the kind of the crux of the question here. And I think under the and per our legal counsel's legal analysis, I feel confident enough to say that it is.
Great. So we found jurisdiction.
Would you like to take comment on that before taking a vote?
Oh, yes. Can we take public comment on the motion to find jurisdiction on this matter? Seeing none? Thank you.
That motion is passed without objection.
Thank you. Member Hinsey, Member Wolf, do you have any questions for the petitioner or the respondent?
I have a question for the petitioner, Mr. Clean. So I heard what you had to say in your presentation. Your actual complaint was specifically regarding timeliness of not receiving the
Was it 67.21?
Receiving the information. Well, that's according to the form that was filled out. So I requested Twitter tweets made by Jeff Kositsky of the San Francisco Department of Homelessness and Supportive Services. Randy Casada replied that they would be provided in 10 days. No response has been received after both follow-up email and 14 days. Mr. Casada's response was agreed to that. So I think, is that the crux of your complaint? I just want to make sure.
No, I think that is where it started off. But then when they provided me sort of like this hacky way to get to them, I find out that records are missing. I've deleted 2 of the very important records. So it's also that they're incomplete. One of them I have a screenshot of because another person who was blocked was able to take a copy of it and posted it on Twitter, and then I put that into the record. The other one is lost.
For the one that you, I'll let you
Go
continue.
ahead. Well, I was just going to say, okay, so then my question, so I guess the question is did you or did you not receive all the information you requested?
No, I did not.
Okay. And which information I'm just doing this by process.
Yeah.
Which information do you feel is still missing?
The tweet, in effect, that he said, I did not say what the newspaper said that he said. And then, although I've received it from another source, it doesn't have the same accuracy and legitimacy that I got it copied from another Twitter user who had screenshotted it.
Do you have that?
Yes,
that
that
included
is
in the record?
in the record. I could look the page.
Yes, that'd be great.
That'd be good. And Mr. Casada, have you provided what you think is all the information?
Yes, we provided him access to the tweets. This is again new ground.
I understand that.
Tweets can be deleted by users. It's sort of a real-time medium that most people are familiar with.
Okay.
Now, to the extent that the the question is regarding access to the tweets and being able to see them. Yeah, that was provided. He's able to see them. Everyone is. They're available publicly. Now, if a tweet is deleted, then it's deleted.
Mm-hmm.
Now, is there a preclusion amongst deleting tweets? This is new ground. I think we need guidance on.
We got
whether
it. It's new ground for us too. Okay, so granted, I hear you.
And I'm sympathetic to the point that, hey, they're a new department and this stuff. I'm not okay with it being, the tweets being deleted.
I understand that, but Mr. Clean, the online private services that are available for the public to use is not in control of the city. The city doesn't have control of it. It's not a city-controlled service. The city may access it, but it doesn't control it like it does email.
Yeah.
Like email, it controls because it has its own server. The city has its own server. It has its own system that sends and receives the email. But Twitter is a private service. It's not. The city has no control over it. And there's no way to retrieve things from it. We don't have subpoena power to be able to force them to do that. To force Twitter to do that.
Well, under the...
You can please in the microphone? Thank you.
Under it was March 2nd decision by the California Supreme Court that when a public official uses some other private service, that they do not get out of the reach of the California. And that's what this case is. It's
I understand that, but if the information is not accessible, or it doesn't exist anymore, then what is there to do? I mean, the point is though the San Jose case really focused more on tweets, text messages and emails that are on devices that actually are saved there. Okay, that would not be saved anywhere else. Okay, so if you sent out a text message on your phone, it would only live on your phone. It won't live anywhere else. It could live in your account, and you can log in your account and get it. But the court also provided that the owner or the custodian of the information was the one to provide the information, and that it wasn't going to extend it anything more than that. So it's somewhat kind of like on the honor system that they would provide it. But that's not the issue here. The issue here is that the person was using a non-governmental system. That system has its own rules. It has its own process, and it may or may not have a record or a log, but it gives the opportunity for the person that's using it to delete anything that's in their account. Now,
I would certainly think that there's a problem of if the city officials are just able to delete public records when their statements are controversial or are not their issue. That was certainly the rationale of the decision, that to avoid those sort of things. And when you read the ordinance, the beginning of it, they kind of talk nicely of saying, you know what? Things are going to change in there. This isn't a one-time rule. Yeah, we're going to have things, and government officials will look for new ways to do it. Look at sort of the broad way to doing it. And it certainly seems unfair to me to say, oh, well, I said something wrong. Let's do everything on this side channel, and as soon as there's a problem, we erase it, and everybody's good with that. I don't think that's the country, the way that the ordinance is asking it to be.
I understand that, but the ordinance was specific about public records prior to the invention of Twitter and prior to the Smith versus San Jose case. And in that sense, records are retained. I don't think there's policy or law that's been created about the retention of social media on a private network or a private system. And so it makes it very difficult for us because, like I said before, this is new territory for us too. We can only adjudicate, much like a court does, based upon what existing law has. And we can only make certain interpretations of it. I'm not comfortable making that kind of interpretation at this time.
And doesn't, though, both the San Jose case and the city government and kind of your procedure say, you know what, when you get something like this, ask the person. When, like, what did they do? They didn't file anything to be saying, well, we asked Jeff, when did you delete this? Did you delete this just when this came out? Did you delete it before? There was they very much avoided the process. And if you're going to now to be saying, you know what, I don't want to get ahead of the big courts in making this decision, there's a value in sort of the courts closer to the people, making statements, and those other courts, when it gets up to a Supreme Court, seeing those rationales, seeing it go through that process. And I would encourage you to do that, and that does seem to be the intention of the way that the ordinance is written and the way it describes when new things come up, how it should be looked at.
But that would then demand that a policy would have to be in place that no public official or city staffer could delete anything or not use social media for the purposes of the business, of their business.
I think there very much can be reasonable rules. Lawyers, I mean, for me to exactly do it, I don't know the rules. And I think that's the process.
Mr. Clean, how would you propose a person not, delete something in their account or in their account, if they were doing the people's business on social media? There's no rules for it yet.
Well, I know for President Trump, they have agreed that if he misspells something, they will keep that. So from the Presidential Records Act,
that's self-determined. That's self-determined unto themselves. He doesn't have to do that.
Well, they have agreed to it, I think, to avoid the going out there and not looking like it and facing like they're not getting a good record winning in court.
Right. Let me take it a little bit more narrower. We are only confined to state law. We're not confined to federal law. Okay, unless there is ample case law that we're told could apply. I'm not finding that here. I mean, if this is all like new ground, and for us to make an interpretation of what the law may think or may say, I mean, the court wasn't confident enough to say how it should enforce getting the information off of somebody's personal device that they own.
But didn't they say that they have to do something, right? They have to ask him.
But there's no enforcement mechanism except that they have to produce it, and it's on the honor system of the person who owns the device. Not even the department or their boss or their employer can take their phone and go find the information. It would have to be produced by the person themselves. So it's a little bit vague on how enforcement is supposed to work in this case.
Or agencies can come up with a policy for that going forward, but the court has not directed exactly how that search would occur.
But didn't they, as you say, they said the honor system. It seems like at least we should apply the honor system and have him answer, hey, when were these deleted? Kind of getting to what's going on.
But even
if apply that honor
I understand
system.
that, but even if he was here, theoretically, and said that he did delete them, you want that information. The information now is gone. So how could the information be provided at that point?
I would think that you would face the same thing as if someone throws away a file or buries. I think there was a couple of years ago, like the sheriff's department or something, like hid a bunch of files like in a corner or something, right? I mean, it's like it's really kind of the same thing. If someone physically hides a file when a request is done, the same thing. You have to at least make a reasonable effort to go out there on the honor system.
Fair enough.
I think we've had, there's a difference there. There's a difference between something being hidden and something being deleted from a space that agency cannot detect. In this case, I am leaning more towards making a motion on the timeliness issue for what was turned over. But besides that, I don't think that we further have control over the situation. I would also, once this action is brought before the full task force, trying to discuss how maybe our technology committee can bring this issue to the attention of the city attorney, and we can figure out some guidelines for agencies going forward in their Twitter use.
At least best practices.
Yeah, best practices, something like that, to give them some guidance, because at this point we don't have any to use going forward.
Well, I do thank you for that, because I think in coming here, partly, I do sort of want to advance the idea that it's improper to delete these. I feel my constitutional free speech rights were violated. This is sort of a platform to get on that. And if the city moves forward with getting a best practices, I think sort of it's time well spent to come up here.
Thank you. You guys can be seated.
Thank you.
Do we have a motion at this time?
I'll move on to find violation of 6721 and timeliness.
Second.
Was that 6721? Oh, I lost my page here.
So I thought 67.21, it must not, well, is for production of electronic versions of public records, access to electronic versions. 67.21, which letter, Victor, I'm not sure if you know, is on timeliness? Specifically.
I think it's B or maybe it's D. Hold on, I've lost my page here. Here we go. Oh, he doesn't give it.
Yeah, it's not in there.
Hold on, I have to go to the ordinance itself.
I believe it would be B, a custodian of public records shall, as soon as possible and within 10 days, comply with such a request for public records.
Thank you. Is that this section that you would like to reference? Yeah.
Come on, internet.
I can also let you use
I
mine.
got it.
I got it.
1B. Yeah, 21B.
So the motion, just to clarify, is to refer the matter to the full task force with the recommendation to find a violation of 67.21B regarding timeliness.
Do we have a second?
Second.
Do we have any public comment on that motion? Oh, hi.
This is weird. So for the sake of the public, I am a member of the task force, not this committee, but I'm speaking as a private citizen who has a complaint that relates vaguely to this situation. So I'm not entirely convinced that the argument that because Twitter is not under the direct control of the government, that the ability to delete messages shouldn't be still under the same rubric as, say, the email that you referenced. For example, if a different municipality, and I realize we're only covering San Francisco, but if a different municipality were to be using Gmail, or San Francisco were to adopt Gmail as our mail client, then we would be using a third-party company to deal with the mail. But because the client has control over the account, they still couldn't delete records. And I think that the same, without further clarification saying otherwise, I think that the same would hold true over Twitter. It wasn't Twitter that deleted the tweet. It was the government representative. Now, if someone who happens to be a government representative deletes a tweet that they perceive to be personal and someone else perceives it to be government related, then we start to get into a very difficult situation. But I think that any tweet that's perceived to be governmental, if it were to be deleted, probably ventures into the existing retention document rules. And although the federal comparison of Donald Trump may not have any actual legal parallels, the fact that he makes a tweet and then realizes he spelled something wrong and replaced it has brought a lot of attention to whether or not that is a violation of the presidential records doctrine and that sort of thing. So I think that the same guiding principles apply even if the law doesn't, and to really think more closely about how the destruction of tweets looks. Secondly, the banning of Twitter users is an interesting one. In the case of Twitter, you can publicly access those tweets. But if we were doing with a public Facebook comment or a public Facebook post, you wouldn't actually be able to see that post unless you were signed into Facebook. And the rules of Facebook do not allow you to have more than one account. And so at the point that you were to be banned from Facebook and then make a public post, that member of the public would be denied it. And although that doesn't apply with Twitter, it does make sense to try to make consistent rules. Thank you so much.
Thanks. All right. Are we ready to take a vote?
So I want to just comment on the public commenter for a second. The application of using Google for the purposes of government purposes would be different. Government would actually have a special account, that special government account which provides auditing and journaling, which is more or less like a major backup system. So I think when it comes to that, it's very different than using standard social media. It's still email.
They're using the platform. They're not actually using the servers.
Right.
Yeah.
So it's a little different. I mean, there's no, company kind of account where you can say we want to retain all the information of all the tweets made by our employees, kind of thing. So it's kind of new ground. Okay. It's a little difficult. That's why I'm only interested. I feel safe enough to just adjudicate on the timeliness issue at this point and not take up the issue yet on the social media or the retention aspect, because I personally, or in my position here, don't feel confident enough to be able to make that determination.
Can I add some public comment?
Is there any other public comment? Please.
Yeah.
Please.
I actually don't think this is the place to spend the good part of a half an hour discussing technical features that may or may not be covered by the Sunshine Ordinance. Some of us don't use them. It's not that we don't have interest, but we're not raised on them. So my preference would be to take the next item on the agenda.
Thank you. Is there any other public comment on this motion? Seeing none, please call the roll.
On the motion, Member Hinsey.
Aye.
Hinsey, aye. Member Wolf.
Aye.
Wolf, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. This matter will be referred to the full task force meeting.
And the full task force can consider some of the other issues that that Dolores Clean has raised. This is just our recommendation to allow it to go forward. Thank you. Please call the next item.
Next on the agenda, file number 17018, complaint filed by Josh Wolf against President London Breed, Board of Supervisors, for allegedly violating Administrative Code Section 67.25 by failing to respond to immediate disclosure requests in a timely and/or complete manner.
Is the petitioner present? Please give the petitioner 3 minutes to make a statement.
All right. So on the surface, there's a pretty clear violation of 6721. I filed an immediate disclosure request asking for a copy of the list of users that had been banned by London Breed's Twitter account. While this may seem like a not simple request, I did provide the actual URL that if you are logged into that Twitter account, it would self-generate, and then you just print the screen. So I felt that could be done in a matter of moments and was well within the bounds of an immediate disclosure request. I didn't hear back from President Breed's office, so I filed up with a sunshine request or a sunshine complaint, and I still haven't heard back. So it's been the window of time for an IDR, now long since the window of time for a normal public records request, and I still haven't heard a response. I haven't heard that this document itself is something that President Breed's office isn't willing to turn over. But there is this element that sort of intersects with what we were talking about previously, where I was asking for who was on the banned list or the block list at the moment of time of that request, which was part of why it was an immediate disclosure request. Breed has since changed over her staff. She may have reassessed who should and shouldn't be blocked, and I have no reason to know whether or not that document is the same some month and a half later or whatnot. And so there's this element of filed the request, it hasn't been responded to, and that document may not actually exist in the same form today that it did when requested. That's really all I have. Thanks so much.
Thank you. Do we have anyone here on behalf of the respondent from President Breed's office? Okay. I'd like to make, or can we, is there a motion to find jurisdiction on this matter?
I move to find jurisdiction.
Second.
Do we have any public comment on that motion? Okay.
The motion to find jurisdiction passes without objection.
Thank you. Okay, so we don't have anyone here from the respondent.
Well, I would say since it's in jurisdiction, we just send it up to the task force and let it run through the process as it is. I mean, the fact that there's been no response to the requester doesn't necessarily determine whether the information exists or not. There's no response to even find out if the information exists.
Victor, did you hear anything from them?
I have not.
Okay. Well, do we have any closing remarks from the petitioner? Then we can.
So this isn't a significant closing remark, but I did mention that I'm a member of the task force when I spoke at public comment earlier. I neglected to say that in my intro statement, so just let the record show that I am a member of the task force, but filing this as a public citizen.
Duly noted.
Thank you. I would like to bring this to the full task force, but if this was a different situation, or in other situations like this where the respondent didn't show up, we usually requested that they showed up before we brought it up to the full task force.
You could possibly add an additional violation for not sending a knowledgeable representative.
I mean, that is a given, but I know that when we had an issue with the internal investigation unit of the police department, and they didn't show up before we brought it to the task force, we required that they showed up and provided certain information. So
it's at the pleasure of this body to do that.
Okay.
I just think it's when it comes to an IDR, if they've gone beyond the maximum number of days and it's like purely timeliness, let them come to the full task force and explain themselves on that.
Yeah, I feel
because it's not really. They've not just been. It has nothing to do with what the information is.
Yeah,
they just have been unresponsive.
I feel similarly, and another way to distinguish this from our case with the police department was in that case they had given some explanation of exemptions to the public to the Sunshine Ordinance, in which they did not need to provide, that we needed clarification on. For example, how it was a pending investigation, what privileges were associated, what harms we were needing to weigh. So in this case, I would feel comfortable making a recommendation that this be sent to the full task force for violation of 67.21, 67.25 for the IDR, as well as 67.26, I believe, for failure to send an eligible representative.
No, not 26.
Let's see.
2.1 is...
We've done 2.1 and 2.5.
Yeah, no, the sending knowledgeable is 2.1. It's contained... Yeah, I think so.
Okay. So we'll do 2.1B as well as 2.1E, as well as 67.25.
Is that a motion?
That's what I'm feeling. I'm waiting for a motion.
I will make that motion for sending it up to the full task force, including jurisdiction, with violations of 67.21B and E and 67.25.
Do we have a second on that motion?
I'll second it.
Do we have any public comment on the motion?
I think it should be 6725A for timeliness.
Would the member making the motion like to make a revision to the motion to add any details?
Any details like the section?
Mm-hmm.
I'll amend to 67.25A.
I'll agree to that.
Okay, thank you. Do we have any public comment on the edit to this motion? Seeing none, can you call the roll?
On the motion, Member Wolf.
Aye.
Wolf, aye. Member Hensy.
Aye.
Hensy, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes.
Please call the next item.
Next on the agenda, item number 7, file number 17023, complaint filed by Anthropo against Margaret Baumgartner and the Office of the City Attorney for allegedly violating Administrative Code Section 67.25 by failing to respond to immediate disclosure request in a timely and or complete manner.
Hello. I think once again it's 6725A for timeliness. So I'm just going to go quickly through a timeline. On March 24th, I sent the initial IDR only to Margaret Baumgartner. I did not receive. Well, she said actually we don't have any case number under that. So I corrected the case number, waited about an hour and a half, and didn't receive a response from her. She's the attorney assigned to street artist. I had seen her in the California State Court of Appeals, and she has never responded to me at all. So I resent the request on the same day to her with the corrected case number. So on the 28th, I had not received an answer, so I asked to open a complaint here. And that was the initial contact with John Cote, the public information officer. To me, how am I supposed to know that a public information officer is going to respond? I don't, and that's the late response. So on March 29th at the Board of Permits and Appeals, Margaret Baumgartner was there. She didn't even bother to make eye contact with me, so I wasn't going to volunteer information to her. On March 30th, once again, I filed the formal complaint, and on April 3rd, came the first response from John Cote. On April 6th, he asked me a question, which I don't need to respond to because it's an interrogatory and not part of Sunshine. And then on April 6th, I once again put the remitter on file. Once an opinion issues in this case, October 6th, 60 days out, I contacted Lauren Curry of the City Attorney's Office. I asked her to put a copy of the remitter on file with the war memorial because if anything happened to me there, if I was handcuffed, that was a potential lawsuit for the city. So she said she was going to do it. That didn't happen. It hasn't happened even as of this morning. That's just me. I'm just trying to protect myself because the city attorney has not been at all helpful in any shape or form. So this is 6725A, a late response.
Is there anyone here on behalf of the respondent?
Good evening, task force members. My name is John Cote. I'm the communications director at the city attorney's office. And I wanted to highlight just a couple of points here. I'll be very brief. This was a situation where we had a internal communication mix-up. On March 24th, I received the initial disclosure, or the immediate disclosure request, from Margaret Baumgartner in our office that had come from Ms. Trabeau. At that point, we had looked at the case number that Ms. Trabeau had provided. I replied that day to Ms. Trabeau indicating we don't have a case number that corresponds with the number you provided us. At that point, Ms. Trabeau did not respond to me. She responded to Ms. Baumgartner. And Ms. Baumgartner sent me the file, and I'm sitting here waiting for Ms. Trabeau to respond to say, here's the case number, and I'll provide the record to her. The only indication I had that this had become an issue was when I received the notification about the complaint being filed with the Sunshine Task Force. At that point, promptly sent the document to Ms. Trabeau, which, as you'll see in your packet, it's page 422. Apologizing for the lateness. And one other point I would just like to note here is that this is, this A, was an inadvertent mistake, but B, this is a document that Ms. Trabeau already possessed. She was a party in the court case. The document that she was requesting was a final court order. If you look at page 434 in your packet, you'll see the affidavit of transmittal that this document had originally been sent to Ms. Trabeau back on October 6th of 2016. So while our office was tardy in responding, it was an inadvertent oversight, and we're sorry that that happened.
Do we have a motion to find jurisdiction?
Move to find jurisdiction.
Second.
Is there any public comment on that motion? Seeing none, maybe we can take that by acclamation.
No objection.
Do we have any questions for the complainant or for the petitioner or the respondent? Member Hinsey, Member Wolf?
I'm sorry, your name again is, sir?
John Cote.
John Cote,
Yeah.
Sorry.
No problem.
Mr. Cote, so just want to say whether or not you have knowledge that a requester has the document in question or not, I don't think bears on whether the ordinance procedurally was administered properly or not. So, so I appreciate your admission on that, but I just wanted to say whether to us it's of really no consequence if no matter where they got it elsewhere prior to making the request, because they got it from a different agency. They didn't get it from your agency. So
Understood.
I don't have any questions at this time. We already have an admission by the respondent, and the issue has been remedied. I think we should just move forward in moving this to the full task force under the current 67.25 section on timeliness.
Yep. I'll make a motion to move this up to the full task force with recommendation of jurisdiction and a violation of 6725A for timeliness.
second.
Do we have any public comment on that motion? Thank you. Seeing none, just call the roll.
On that motion, Member Wolf.
Aye.
Wolf, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. This is one of our new situations. I believe that both parties agree that a violation has occurred. As it goes forward to the task force, do you believe that both parties need to be present at that time, or?
I don't think there's any necessity for that, unless they feel there's some new and compelling evidence to provide. If not, then they're excused from, I would suggest that.
May we send it to next week's meeting? As the chair of the full task force, Chair Wolf, may we send this to the full task force for next week's May 3rd meeting?
Yes.
Thank you.
Thank you.
Thank you very much.
You didn't ask for a rebuttal. There are just 2 points that I want to make. That
Okay, we can give you. We'll give her 1 minute to do a rebuttal.
There was every opportunity for Margaret Baumgartner to respond to me. She was present at the California Court of Appeal. I'd gone into the reception area, left a note for her after the opinion issued. I left a couple voicemails with my contact information, and the entire focus was, we don't need to deal with you. You're not a lawyer. So I feel completely dissed by that, and also the fact that she's not here tonight to take the responsibility for her actions. She was completely snotty the entire time.
Thank you.
Thank you so much.
Please call the next item.
Next on the agenda, item number 8, file number 17024, complaint filed by Gregory Berlin against the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code, Section 67.21, for failure to respond to a request for public records in a timely and/or complete manner.
Good afternoon, task force members. I just wanted to briefly state that although the agenda states that I filed this complaint, I just wanted the record to reflect that I filed the complaint on behalf of Aqua Terra Aris Law Group, which is an environmental law firm in the East Bay, and I'm an associate with that law firm. We filed this complaint pursuant to Administrative Code Section 67.21 because the tax collector office failed to respond to 3 separate Public Records Act requests that we made. I'm just going to briefly go over the timeline of our requests. On October 20th, 2016, we submitted our first PRA request to the Office of the Treasurer and Tax Collector via U.S. mail. We specifically requested A, permits, licenses, and certifications, B, documents containing reference to the number of employees, C, corporate and officer contact information, D, written correspondence and communications with the business entities or employees, officers, or directors, and lastly, all documents related to the businesses that were attached to the PRA request, and all of those businesses were medical marijuana dispensaries located in San Francisco. We did not receive any response to the October 20th request. On December 7th, we submitted the same request and did not receive a response to that request. On March 20th, I contacted the tax collector's office via telephone to inquire about the delay. I was informed on the phone that I could make the request in person or that they could fax but not email me a document request form. On March 23rd, I went in person to the tax collector's office to inquire about the delay in my request and was informed that I could sit down, take a number, fill out the document request form, and someone would help me. After my number was called, I was informed that they would have to forward the request to their legal department and that they would not be able to answer my request in person despite what I was informed on the phone, and that they were also going to look into why they never responded to our request. 10 days passed, and close of business day, I filed this complaint as I did not receive a response to my in-person request. I filed the complaint on April 3rd. And then on April 4th, we received a response from the tax collector's office claiming that the requested information is confidential. So I guess the main issue right now is no longer the timeliness, because we received a response, albeit the response was late, and we made three separate requests, and we didn't receive a response to the first 2, and the response to the third in-person request was late. Now we're concerned that the response is incomplete because no documents were provided, and we believe that their basis for not providing those documents is not legally sound.
Thank you. Is there anyone present to speak on behalf of the respondent? Please identify yourself.
Good evening. My name is Deborah Liu. I'm the Assistant Tax Collector Attorney. And just so you understand the background of the process, how we get our mail is if mail is addressed to City Hall, it goes to the cashiering section. If it's a legal matter, we need our mail right away and it goes into bins. Otherwise, all mail is scanned. The assistant, after we became aware of this problem, I had the assistant manager check all of the scanned mail, and we found no October 20th letter, and we did not find any December 7th letter. Because the legal section handles the Public Record Requests Act, we know and how to process it, and we act on it right away. We have no record of ever receiving the October letter or the December letter. So we apologize. We've checked with even the manager to recheck the assistant manager's job of scanning. She has special abilities or ways or tools, and she has not been able to find those two requests. So we apologize. We don't have any answer for that. It just seems like we didn't get it. Anyway, as soon as TPA did get the response, by the way, let me make one clarification, which is the manager of taxpayer assistance was there when the associate came in and made the request. She says nobody went in the back room and got a separate copy of the request. She was there. She saw her clerk make a copy of the request that he had brought in, and she's the one who made the comment, oh, this should go to legal. Regardless, the response was due on Monday, April 3rd, and I'm the one who has to sign off on the request, and I wasn't here. But when I got the package and it was put together and redacted, on Tuesday, I signed it and got that off right away to their offices. The next day, I called up to make sure everything was okay. I spoke to Mr. Berlin and Mr. McClare, and we did some meeting and conferring about what should be disclosed, and the only problem that I understand they had was the number of employees. We gave them legal citation, an additional legal citation at their request as to what constitutes a legal return, but it seems pretty specific that the ordinance provides that information that is on a taxpayer's return is confidential unless it is permitted by this section or required by law, and that's under Business Tax Code Section 6.22-1. So then we look to the Government Code 6254 subsection I that says no disclosure is required if the information is received in confidence or would result in an unfair competitive disadvantage to the taxpayer. And the information they seek, we explain to them, would otherwise violate our bounds of being confidential from information.
Thank you.
From the taxpayer.
Thank you. Do any of the task force members have any questions at this time?
Ms. Liu? So while I understand your citation regarding the ability to withhold the information, the complaint is not speaking to that particular point.
Initially when we got it, because it was sent on the 3rd.
Actually, the original request was on 10/16 of 2016.
Oh, okay.
The second request came, to follow up was on December 7th. So that was almost just under 2 months later. The limit is 10 days.
Right. And
so
as I was saying,
I understand that something got lost in the sauce in your department, but to not...
That is, I don't know if it was the mailman's fault. I don't know if it's our fault.
Well,
we looked diligently.
I understand.
It was not there. It is still not there.
I understand that. I understand what you're saying. Then on March 20th, the associate contacted by phone
311. Yes.
To inquire about the response and didn't get a response. 311's pretty good about making sure if that's the case, I'm going to ask him in a second if that's how he contacted you. But 311, I use 311 all the time for public requests, and I'm usually get a call pretty
From
quickly.
my understanding, the request was not made in that phone call. Maybe there was an inquiry as to what's going on with that.
Right. Doesn't have to keep requesting it every single time. He already made the request. So he's asking for a follow. He assumes that you got it. Nobody is responding to him that they got it or didn't get it. So that's a problem within your department.
I will look into it further.
Okay. Mr. Berlin. So when you originally sent the October 20th request for information, was that sent by certified mail?
It was not.
Was the second one?
No, it was not. First of all, although they claim that they did not receive those 2 responses, and I do have a rebuttal to that, the third response was made in person, and their response to my in-person request was not timely.
Okay.
And they can't get around that one. Also, they did go in the back and pull my request, and I know that because they came to the desk and gave me a copy of it.
Do you have a copy?
I don't have the copy is attached to our complaint. What I did when I received that was there's an attachment A to the Public Records Act request with a list of businesses, and I circled 3 of the businesses and told them, you only have to limit it to these 3 businesses. We no longer need information on the remaining businesses. So the document they pulled from the back did not have my annotations on it. The one that I gave them had annotations on it. So
are you telling me that on March 20th, when you went into the tax collector, they actually had the
They pulled it from the back and brought it to me.
So they
and they said they were going to look. Yeah, and they did. And they said,
okay.
And they said they were going to look into why there was no response to it. And when they gave me the copy, I annotated their copy and said, I only need these 3 and information on these 3 entities. Also, I did not call 311. I called their receptionist desk, and when I went in person, the receptionist, when I told her what my issue was, actually recalled me calling her on the phone and speaking to her about this issue, and she was the one that told me I could make the request in person, which turns out I was not able to do that. The request had to be forwarded to the legal department. In regards to also, I know Ms. Lewis stated that the information is confidential because of Section 6254.
Yeah, but that's not before us today.
Okay.
Your complaint was not based upon the response that you got.
So I guess my question for you would be then, I understand today's hearing is about the timeliness of the request. Now we believe that the request is not complete and that their basis for denying our request is not legally sound. Would we have to have a continuance, amend our complaint, resubmit our complaint? How would we have to proceed procedurally? And I'm not sure what relief, if any, you can give us at this point for their failure to respond.
We'll get to that.
Yeah.
I don't think it, to me, I don't think it's attached. There's no context. No context in the actual petition for the hearing that describes the information at all.
I mean, at the end of the packet, there are a lot of documents that were provided. There are a number of tax records and business licenses, and things that are marked out.
Again, that's not part and parcel to the actual
complaint, yes.
Even as it was presented to us by the petitioner at the beginning of this hearing. So I would...
I'm struggling with the context of...
Yeah, I mean, I would say that if you wanted to file another petition for hearing based upon whether the information you received was adequate or not, or responsive or not, that's up to you.
And we can dispense of it all at one time. We're not making any recommendations to you, but if you actually want the information versus just getting a finding against the department, that is what you will need to do.
Okay. Our office would like a finding that their response was untimely.
Mm-hmm.
even for argument's sake, if they did not receive the paper request, the in-person request was definitely untimely. And then if we could have some sort of continuance or I'll amend the complaint to get to the more substantive issue of whether their legal rationale for denying the request is sound, I would do that as well.
I'm not interested in having it amended. You have to
Refile.
Refile.
Just file a whole new.
Okay,
Just
so
on that.
we
Just
will
on
do
those
that.
points. But
At this
Go to
time,
rebuttal.
we can hear a rebuttal and we can consider the timeliness issue and whether to move this to the full task force on that issue.
Right.
Can we hear a rebuttal from the respondent on the timeliness issue?
On the timeliness issue, Mr. Berlin came in on March 23rd, not the 20th, I believe. That's when the request was received by taxpayer assistance, and it was sent over to legal department. Either on I think it was sent on the 23rd, and I think we got it on the 24th. But if it were the 23rd that he was in, the last day the 10th day would be on the day that they filed the complaint to the task force. And I would be 1 day late because I was not there on Monday to sign. And so I apologize for that.
Thank you. Do we have a rebuttal from the petitioner?
I mean, I understand that it was only 1 day late. We submitted at close of business day for when the response was due, and I understand it was only 1 day, but it's still untimely, and we've had a lot of issues with this office. I know other people have well, and I just, for the record, urge them to, if there's only one person that's responding to PRA requests, if there's some issue with that, I mean, that's not really our issue at the end of the day. We're representing a nonprofit consumer advocacy nonprofit consumer advocacy organization that's trying to protect the California public, and that's our concern, not the issues within this department.
Thank you. Do we have a motion at this time?
So I'd like to move and find violation of 6721 A and I think B. Get my ordinance out here. Come on.
What's the other issue you're looking for?
No, I'm just looking for the ordinance. It just keeps refreshing on me, so I have to wait for it to reload. 6721. Yeah, 6721B. Yeah, 6721B, and this will be on the original submission, considering that when Mr. Berlin or the petitioner had gone in person, they actually had found his original request.
I know. Okay.
I'm not going. I can't base it on the.
I mean, he said that, but there's nothing in the packet that shows that. But
okay.
that's why I'd be more inclined
okay.
to just go with the March 23rd
Well,
violation. That was a day late.
I'm more concerned with the situation that happened prior to the 23rd. Because we're talking about 6 months, almost 6 months later.
I think if there was like a certified mail indication, then I would have felt more comfortable with it. I'm concerned that that's basically.
Well, let me ask.
And if that person had been present that he spoke to and said, "I did have that piece of paper. I did find it in the back."
Let me ask two questions. So, Mr. Berlin, do you have a copy of the original request?
I do. It was attached to our complaint.
No, but
as well.
do you have a copy from when you went in person? Did you get a copy from them with a timestamp on it?
No.
That's the timestamp would help. That's
Right.
I know in my agency there's a timestamp on things.
Right, when it's received. I mean, if you had
There was no timestamp.
Okay. The hard part is the evidence that anything was received by a tax collector in their system, and the fact that your testimony. I am inclined. We can't swear anybody in under oath. Okay, but and I'm inclined to believe you that you went back in. I would actually maybe prefer to hear from the actual person. Do you know that person?
I'm not sure of the individual's identity.
Okay.
I don't remember if it was Miss Liu who I talked with on the phone, but we were trying to get to the bottom of who the individual was at the desk that I was dealing with.
All right.
But
So
there was no issue with the address that I sent it to. No one ever said that was an incorrect address. We submitted it twice. We use certified mail for certain submissions, but we make several Public Records Act requests and never use certified mail. And this was the first time we make them to agencies across the state that any agency has ever said to us that they did not receive our request.
Right, and I have no problem with that. It's just that you are not sworn, and we don't have it in the packet, and we're going to have to write up an order based on what was in the packet. And so we will not have, just like you saw the person earlier, he was holding the draft copy, he had it in his hand, but it wasn't in the packet, so I couldn't.
And I don't have internet connection here, but I'm sure email correspondence with their office, they responded to my request, so they got it somehow, and she just admitted that it was 1 day late on the record.
Right, that would be the March 23rd item. That was March late.
That was March 23rd?
Yeah. The in-person request was on March 23rd, yes.
Okay. He was trying to give you the earlier date. That was what we're.
I understand. I understand.
Yeah, I'm a little more concerned when I hear 6 months goes by.
And we were concerned with that as well.
That's more of my concern. Okay, then we'll hold it on the most recent date then. Okay.
Do we have a second on that motion?
Yes, Member Hinsey.
Second.
Oh, she did? Okay. Do we have any public comment on the motion? Seeing none, please call the roll.
On the call, the roll, Member Hinsey.
Aye.
Hinsey, aye. Member Wolf.
Aye.
Wolf, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. This is another situation. I believe the parties acknowledge that the response to the March 23rd request was late. Is that? Have you acknowledged the findings of this committee at this time, Ms. Liu? I acknowledged it. Yes.
She said into the microphone that she was 1 day late. She acknowledged that fact.
Yes. Do you believe the parties are needed at the full task force?
We can ask them, would you like to appear before the full task force, or would you like to waive that and we can hear it without you being present? This would only be on the timeliness issue.
Yeah, we can waive it on the timeliness issue. We're more concerned at this point with the substance of their response, but of course we still would like to hear a decision from you.
Yeah. Ms. Liu, would you like to be present?
Yes, I'd like to be present.
At that meeting? Okay, so we'll schedule it so that you have to appear.
Okay.
There is another reason you might not know. You might want to be present because the full task force could go a different direction than we have, and they could rule against you. So that.
Well, then I would want to appear then.
Okay.
Schedule it.
I will notify the parties when that is scheduled. Thank you.
Okay, but I do have one comment, if I may, and I don't know if it's already too late to make this comment, but we have a new legal assistant, and he thought it's when the legal section got the document, not when TTX got it. So that would be our good cause.
Okay, well, that's incorrect.
I know, I'm just saying.
Oh, that's what was going on.
That's what I'm saying as to what also
was going on.
We didn't know that, there was confusion, but.
Thank you for training him now. Yeah.
But we do our best.
Thank you.
The matter will be referred to the full task force for hearing.
Thank you.
And I assume that the petitioner will be filing a separate complaint regarding the documentation.
Yes, we intend to do that tomorrow or the day after.
If you're going to send it by mail, please do it certified.
Please call the next item.
Next on the agenda, item number 9, file number 17025, complaint filed by the San Francisco Urban Forest Coalition against Michael Ang, Jonas Ionin, and Christine Silva, Planning Department, for allegedly violating Administrative Code Section 64.24C, 67.25, and 67.34 for failure to respond to immediate disclosure requests in a timely and/or complete manner.
You want to give me 3 minutes?
Yes, please.
No,
Thank you, Victor.
Thank you. As you probably noticed from the filings, the IDR was filed on a Friday, March 10, response due March 13. The process followed by the Planning Department started on March 10 and continued until April 5, a total of 26 days. So no matter how you slice it, it's more than 3 weeks after receipt of the IDR, and that's not the purpose of an IDR. So what they actually did is they had the records available on the 16th from their memorandum, and but they kept them, could have sent some of them to me, but kept them all while the person whose employment records were involved sat down with a representative of the Planning Department and reviewed each one to see what was redactable and what wasn't. In fact, the IDR said to redact all personal information, and the Sunshine Ordinance itself describes what should be redacted. So they took another 10 days to consult with the city attorney based upon a provision in the ordinance that allows for that extension, except it doesn't apply to the city attorney. It only applies to departments who have either the records or whose records might be involved. So, needless to say, the problem is that they've created their own galaxy. They don't have the custodian of the records respond as required under the ordinance. They have a person who's designated as the manager of Commission of Affairs. And she undertakes all the responsibilities for dealing with these public records, although she's never been trained to that task. And it's a clear effort to get around the provisions of the Sunshine Ordinance. So, you know, the long and short of it is that it ignores a number of other provisions in the ordinance. One, that the work of responding to public records requests and preparing documents for disclosure shall be considered part of the regular work duties of any city employees. So the Planning Department doesn't believe that that's what the law is. And then, of course, there are any number of reasons why this is pretty much a willful delay triggered by their own means.
Thank you.
That's my 3 minutes.
Thank you. Is there anyone present on behalf of the respondent?
Good evening, Chair and members of the committee, Christine Silva, planning staff. On Friday, March 10th, the Planning Department received an immediate disclosure request from the complainant requesting personnel records of Christine Ha, Enforcement Manager. The following business day, we invoked an extension due to the need to consult with departments. We immediately determined we would require guidance from the City Attorney's Office as well as Human Resources, since our office rarely receives requests for an entire personnel file. The nature of the employee's privacy interest in their personnel file is a very sensitive one, and we wanted to be very careful in reviewing the files. In addition, we contacted the affected employee, Ms. Ha, as a courtesy, and also began collecting records from AHR staff. On Wednesday, March 15th, our HR staff completed collection of the records and consulted with the city attorney for review of those records, in addition to the guidance. During this week, we also met several times with Ms. Ha and her union, IFPTE Local 21, as she had concerns regarding disclosure of private information. We also spoke with the city attorney to answer questions regarding the personnel files. On Tuesday, March 21st, staff completed review of the records. A second set of records required additional review and follow-up. At that time, staff contacted the requester and began redaction work on the first set of records. 2 days after the deadline, on March 24th, staff completed redaction work on the first set of personnel records and produced those records via email to the requester. On Monday, March 27th, staff continued review and discussions regarding the second set of responsive records, and staff completed their review on April 3rd and was able to complete all redaction work and produce the second set of records via email on Wednesday, April 5th. As of April 5th, all responsive documents have been provided to the requester. At this time, the department acknowledges that we are in violation of Admin Code Section 67.25 and that we exceeded the time limit allowed. As explained, our office rarely receives this type of request and sought the guidance of the city attorney, which ultimately added to the processing and production time of the request. Disclosure of an employee's private information is not permitted, and we needed to be very careful not to disclose any private information that was contained in the personnel files, while at the same time complying with the Sunshine Ordinance. We take these issues very seriously. The complainant also alleges that we are in violation of Admin Code Section 67.24C. That is incorrect. The required information has been produced pursuant to that section. In addition, the complainant alleges that we are in violation of Admin Code Section 67.34. That is also incorrect. As explained, our staff worked diligently and carefully with all involved parties, including the requester, HR staff, city attorney, Ms. Ha, and Local 21, to identify, properly process, and produce all responsive records. Jonas Ionen of staff is also here to speak. Happy to answer any questions.
Are there any other speakers on behalf of the respondent?
Not limited to time.
You are limited to time.
They only have 10 seconds left.
Okay. I couldn't see the thing. Okay. Thank you. Do the members of the committee have any questions for the complainant or the respondent? I do. We can get started. Can the petitioner please approach?
And good to see you, Mr. Grossman.
Hey, Bruce.
Are there any documents that are still outstanding? If so, can you give us?
No.
Okay.
There were 78 records that were finally sent to me. They had them in their possession on the 15th. I got the last half approximately on April 5th, and that was the day that they got a copy of my complaint, even though I had filed the complaint with a city fax number on the previous Monday, which would have been the 3rd. So anyway, I wanted to
So for 67.24, the violation under 67.24, is there anything still outstanding? So I was looking in your complaint.
Yeah, there is actually. There is actually.
Okay. Which ones are those that you still, or what info do you still need?
I sent Ms. Silva Section 6734.
Oh, no.
D, I think
The
it is.
6724?
No, I'll tell you. 24D, yeah.
Okay. On the complaint, I think we have 67.24C.
Oh, 34, the deliberate.
Okay, so we have 67.24C,
Yep.
and so that includes public information that must be disclosed. It's mostly about employment or
Okay,
personnel.
let me respond to that.
67.25 and 67.34. So I'm trying to figure out 67.24 if any of that personnel information that you should have received has not been received.
Well, I find it surprising. There's no employment application.
Okay.
There's no CV or resume, which you would think would be the first two documents or records. It's a long story, which I won't bore you with. But this, the reason I asked for the records was I was confused by the fact that the person who in that position had a planner for classification, which is the highest manager you can be, and yet there was no evidence that she ever went to college, for example, or did anything like it. But on
It's okay. I mean, we don't need to know why you need it because we don't want to judge
no,
you
I
or
understand
whatever.
that. It's my one opportunity to get it in.
So I know that when city jobs are posted, the application process is, you might not submit an actual CV, but you would enter in all the information that would be on your CV into the system.
Yeah.
Did you receive anything like that?
No.
Okay. So application and resume CV are outstanding. Let's move to 67.25B. And
6.2.
And that's with the IDR, and we have information both
Right.
from you, and they've admitted that they were late on responding to that.
They were late primarily because they needed to talk to the city attorney on how to redact, even though that's what you would think everybody should understand, what's private, It's even in the ordinance. And then the main cause was meeting with the person whose employee records were involved to get her input and her labor representative's input on what to do about these 78 pieces of paper that I was going to get.
Right. So 67.25B, it makes reference to the need to consult with another interested department. And so in this case, the department was the city attorney's office, correct?
Yeah, but it's not a reason. It's not a department. That's number one. Number two, it is only if, as described in that section of the ordinance, voluminous, or I forgot what it is. My memory isn't.
If the voluminous nature of the information requested, its location in a remote facility, so it doesn't have to be voluminous or a remote, or it says, or the need to consult with another interested department warrants an extension of 10 days. I'm not going to argue with you about that, but this is the section that one of the sections that you are bringing a complaint under, right?
And the reason is the city attorney is not a, quote, interested department, close quote.
Thank you. And then for 67.34, the willful misconduct. So for that, you're saying it was that there's evidence of willful misconduct because you know that they had the documents on the 15th, and yet they didn't produce them? Or what other evidence do you have of willful misconduct?
The reason I say it's willful is they circumvented the statutory requirements that are intended to provide speedy public access to public records. They created a system of their own that prevented me from getting them when they had them.
And that system included meeting with the city attorney, or what was that? What do you mean by the system that was created that showed willful misconduct?
The system was that the person to whom I submitted the request was the manager of human resources for the planning department. Mm-hmm. He had the records, but he didn't do anything with them other than to pass them along to this now mysterious public records entity that the planning just set up. So that's the nom de plume of Miss Silva. So she sits on them after receiving them on the 15th and 16th to do what? To talk to the city attorney about how to redact them or what's in there. It's right in the law. Secondly, to sit down with the employee involved. When is that a part of responding to public records? So they did this really to accommodate an employee and her union representative so that everything would be on board the way they want it.
Can I interrupt you?
Yeah, I'm done with my questions. Do you have any questions, Member Hensey? Okay, Member Wolf?
So I would just say that with regards to the part around the attorney, 67.26 allows for the work regarding disclosure. So information that is exempt from disclosure shall be masked. Shall be masked, deleted, or otherwise segregated in order that the non-exempt portion of a requested record may be released and keyed by a footnote or other clear reference to the appropriate justification for withholding required by Section 6727 of this article. This work shall be done personally by the attorney or other staff member conducting the exemption review. So the fact that they submitted it to the city attorney for help on the redaction portion that they claim is appropriate under the exemption, I would see that they're in compliance with the ordinance with regard to that. I understand your point that under 6725, that asking another department that's uninterested, but here the city attorney was actually doing the redaction work.
No, they weren't.
They weren't?
I don't believe so.
According to their testimony, they were.
Is it in the response, that memorandum? I can pull it up,
I
but
don't know.
I don't recall that. I thought they did that with Ms. Haw and the labor union representative.
Well, let's ask them. Ms. Silva?
So
What was the purpose of your interaction with the city attorney on this case?
We sought guidance for them for review of the redaction. So we of the items that needed to be redacted. So we forwarded them the responsive records. They marked all the redaction. We received those.
Who marked all the redaction?
City attorney.
Okay.
And then we reviewed them and formally applied the redactions.
And is there a memo attached or that you may have received from the city attorney describing the work that they did for you? I mean,
No.
they charge your department by hour.
Yeah, I guess that's true. We don't.
There's no memo citing the actual work that was performed. I mean, we should probably start that as a practice because they do charge us quite a bit as part of the advice we seek from them and the advice they provide to us. But essentially, we provided them the entire personnel file, okay, which we feel to be very sensitive information on it by its nature. So we didn't want to screw it up. We asked for their guidance. We don't get these requests on a regular basis. Essentially, they divided the personnel file into 3 piles. One that, hey, you can disclose this with minimal redaction of personal information. Here's a pile that, we're they needed to even consult internally as to whether or not it could be released. And then there was a pile that said, we cannot release this information, okay? So as soon as we got that information back, we released the information to Mr. Grossman that was after it was redacted. And then there was the second pile that was still being consulted, which was the further delay. And I do apologize for the delay. We never want to delay, especially for immediate disclosure requests or any public record requests. But I guess what we would like to impose upon you is sort of this rule of reason, the sensitive nature, first of all, of the records that are being requested, and the fact that we had to go to an outside agency to consult, and I think the outside agency we consulted was fully appropriate. And then furthermore, the interaction with the employee was, as a courtesy, they were advised, and then they brought in the union, and so we sat down with them. But I don't believe that amounted to a significant delay in the actual issuance. And the reality is, we did get suggestions from the union and the employee to withhold certain information. We disagreed with them on most of the requests and provided that information to Mr. Grossman. So anyway, that's the only thing we really wanted to impose upon you, is just sort of in consideration of the rule of reason in this matter.
Well, for me, the rule of reason issue is still the only issue I have with the rule of reason is proof that there was a need to cite or activate or enable the rule of reason. And I think there needs to be a little clarification on how that gets applied here for the Sunshine Task Force. We know that we have to accept the rule of reason as a active process, but we do demand that there be proof, that there be a reason to activate it. Can't just state it because it may be that way. So chronologically, memos, things like that, to show when items were sent, and you had to wait, and that you had a memo from from a supervisor that says this needs to go to these 4 departments, and it's going to take this much time, and that could be a good good notations for citing the rule of reason. That said, let me ask you, Mr. Ionin, was there any portion of how much of the portion was releasable, and when was it released? When were you told that it could be released?
I think,
or Ms. Silva.
Ms. Silva can probably better answer that.
We did 2 productions, one on the 24th, which was 2 days after the deadline, and then the other set on April 5th.
On the 24th.
So those emails are attached as Exhibit D and E of your packet, pages 603 and 607.
Okay, and according to Mr. Grossman's testimony, he received that first part on March 15th?
No, March 24th.
March 24th. And the second part came on March 5th?
No, April 5th.
Oh, April, I'm sorry, April. I wrote here 4-5. Yeah. Okay, 24th. Okay, thank you very much. Okay.
Any other questions? Can we give, Victor, can you give each party a minute for rebuttal, please? We should probably hear from the respondent first, so that you can have the final word. Respondent first, and then you'll have the final word. Yes.
What did you just get?
Those were
No, I asked a question.
questions.
We were just asking questions.
Okay. Does the respondent have any rebuttals? I mean...
No, you guys go first, yeah.
Yeah, he gets the final word.
I guess just to reiterate that we did not hesitate in responding. We received the files from our HR. We immediately recognized the sensitivity of the nature, forwarded the information onto the city attorney's office that works with us regularly. They had to consult internally. We had to actually perform the physical redactions of each of the sheets and add the footnotes. All of that takes quite a bit of time. And so we would just appreciate your consideration of the sort of the reality of the situation.
Thank you.
Yeah, I appreciate it.
Can we hear a rebuttal from the petitioner? Thank you.
There were 78 records, not sheets, but 78 records, most of which were single pages. If I told you that the redactions are probably on less than half, would it surprise you? And secondly, why didn't the manager of HR, who had the responsibility of reviewing them and sending them to me, and who no doubt is very familiar with the rules regarding redaction of personal information, which is actually in the ordinance, what is to be redacted, he could have done that for about the same time it took me to go through those records, maybe an hour and a half. And as the Sunshine Ordinance says, that's part of his job. That is part of his job. And if he hadn't seen a request for employment records previously, I would be very, very, very surprised.
Thank you. Do we have a motion at this time?
Get the record out.
Before a motion, we can discuss. I have some of my feelings on this case so far. Looking at 67.34, the finding to find willful misconduct, I think that the creation of a system for handling of Public Records Act requests, I don't think that would be identified as willful misconduct. We have advised many agencies here that they need to have some type of a system in place so that we can formally see how they handle Public Records Act or Sunshine Ordinance requests, and that is, I think, what has been demonstrated here. I think that if we had seen something like an email that said, don't give out those records, or something like that, that would be needed in order to identify a willful misconduct, or if we had recommended many times that they have a system in place and they did not have a system in place, that would be another example of willful misconduct. The violation under 67.25B for the city department, consultation with the city department, I agree with Member Wolf here that the city attorney's office would qualify as an appropriate consultation. Just because a set of records may not have multiple redactions, it's still I'm an attorney, I do redact documents. It's incumbent upon us to look at every single item and identify whether it falls into an exemption or not. And so even if if several items do not end up redacted, it was still a requirement for that attorney to look at and inspect each item to say that they have performed their duties in reviewing items for redaction. So those are my feelings so far. Any other feelings from Member Hinsey or Member Wolf?
I'm just inclined to find timeliness.
Okay. And so that would be under section
6725.
Okay. I'm inclined in the same direction. There is a certain amount of time that's allowed as an extension, and I think here they have gone over that amount, especially with the timeline on page.
And actually, it would. Let's see. Yeah, I was going to suggest 6726, but the question, I would say 6726. I would have to ask one question that we didn't get to ask that the petitioner had brought up. Would you mind if I can ask that question? Okay.
Go for it.
Either Ms. Silva or Mr. Ionin. Mr. Grossman stated that in the documents he received, there was no employment application or resume or CV or anything like that, which seems to probably be the very first pieces of document that would be in somebody's personnel record. Can you respond to that?
Well, I can't respond directly as to why. When we received the personnel file, it didn't include that information. The employee in question was a long-standing employee of the city and county of San Francisco. She transferred into the planning department from another department. The planning department itself may not have ever actually held or been in possession of an application from the employee in question.
Okay, so you're just saying that that part would be just unresponsive. You have no.
Well, it wasn't in our possession.
Not in your possession. Okay, great.
Yeah.
All right.
Yeah, and I did have a question. I don't know if this would be appropriate time about timeliness associated with the immediate disclosure request.
Sure. What's the question?
We didn't invoke this here, but I was searching for the task force and the committee's thoughts on the city attorney's advice in the Good Government Guide under immediate disclosure requests and the timeliness of it. The second paragraph under that section B, it says the purpose of the immediate disclosure request is to expedite the city's response to a, quote, open quotation, simple, routine, or otherwise readily answerable requests, close quotations. pursuant to Administrative Code Section 67.25A. The Sunshine Ordinance specifies that for more extensive or demanding requests, the maximum deadlines for responding to a request apply. And thus, the requester's designation of a request as an immediate disclosure request does not automatically make it so. Rather, a department may adhere to the time deadlines governing standard requests, an initial 10-day period for response, plus a possible extension of up to 14 days. That's their language, the 14 days. We've been dinged on that now. We've corrected it. We're doing 10 days, but it's still in there. If the extensive or demanding nature of the request would impose an undue burden on the department to respond immediately. And so I'd like you all to take that into consideration today, but also if you choose not to, I guess, point to this section of the Good Government Guide, if you could give us some direction as to how we can use that in the future.
Thank you.
So can I just respond to that real quick?
I mean, my initial thought is, I mean, his request did note that redactions would have to occur, which makes me slightly concerned.
Right. My response to that is in 6725D, which speaks to incremental or rolling basis. So as Mr. Grossman was saying, provide me whatever you have that's not needed to be redacted or can quickly be dealt with, release those within the time frame, 10 days, which should be an adequate amount of time for somebody to do that. And then anything else that takes longer, you provide it on a rolling basis. Okay.
I was just going to comment on the issue raised by the city attorney, which is that the Good Government Guide represents the city attorney's take on what will be the most benefit to his real clients, who are the city departments and agencies. And we know there are a number of things in it that are just plain wrong. So putting that comment in, I don't think gets us very far. I think the long and short of it is, it took over 3 weeks. I had to file a complaint before I got something that had been promised to me the week before, and so forth and so on. So there's more than timeliness. It's somebody actually responding in a way that indicates that they care about getting the information, the public records, to the requester.
Thank you. I think you were working on a motion, Member Wolf.
Yeah, I would just say it was on timeliness, 6725A, and B. No, 6725A.
Do we have a second?
Second.
Do we have any public comment on that motion? Seeing none, Victor, can you call the roll?
On that motion, Member Wolf.
Aye.
Wolf, aye. Member Hensy.
Aye.
Hensy, aye. Chair Tesfa.
Aye.
Tesfa, aye. The motion passes. Mr. Wolf, would it be possible to have this item heard before the full task force on May 3rd?
Yeah, sure.
Is there any objection by the parties to have this heard on May 3rd?
Mr. Grossman?
We're going to refer this item to the full task force for May 3rd. Is that
Available?
acceptable?
Thank you.
Thank you. Next on the agenda is item number 10, announcements, comments, questions, future agenda items, and pending calendar.
I don't have anything for this item. Victor, do you?
No.
Any of the members?
Didn't we speak about having, the meeting with...
There's a potential meeting with a complainant to discuss multiple complaints and possible resolutions. We were hoping that you would be
amenable
to hearing that before the complaint committee.
The basic context is a respondent, a requester making multiple requests to the same respondent.
Okay, I think if the respondent is noticed of that, they don't need to be made to appear, but they need to be provided notice
I
that we will
believe
be.
both parties would need to be present.
Yeah,
Okay.
this would be a discussion
Okay.
about how to deal with it in this particular context to try and alleviate.
Okay. I'd be,
It's an intervention.
yeah, I'm fine with that. Please take that into consideration when creating the agenda for that meeting so that we allocate enough time to
Yes, definitely.
dispense with that matter. So maybe fewer complaints on that agenda.
Yes.
Okay. Or none.
Mm-hmm.
Or none, but besides that item. Okay.
Sounds good.
The other thing I wanted to mention is with regards to the which case was that?
The Twitter one?
No, the Kaczynski one, the Dolores.
Yeah, that's Twitter.
Yeah, the Twitter
Yeah,
one.
the first
Yeah,
Twitter.
I'm sorry, I didn't
The
hear
first
you for a second. So with regards to the first Twitter one, I think I definitely am going to need some guidance on that, and I think we should try to avail ourselves before and continue any other items with regards to that. And the reason why is because Smith versus San Jose focused on voicemails, text messages, and email only. Didn't focus necessarily on social media. So the fact that because something it can be accessed on a mobile device or a tablet or a laptop or a desktop is of no consequence. It's all online. So the difference is where something gets saved. And that's really the issue that's happening here.
Right. And I mean, the city can give guidance to its departments saying that our new policy is that maybe you can't use Twitter anymore.
Right.
I mean, I'm not saying that's what they should do, but in Smith v. San Jose, it gives the departments the ability to create policies. And if this is one where we don't have access to the server, we cannot retain documents under our standards, then we need to evaluate how we go forward.
Right. So I think we need to get some guidance and then create some guidelines for us, which will have to be ongoing as these kinds of things begin to change, either in court or at the legislature.
Right. And I mean, it does remind me of some of the issues regarding the different text messaging apps. I don't want to mention specific ones because there are several that way which allow for messages to disappear. And in that case, the holder is not able to access them to produce them.
Right. And the service doesn't retain any logs.
Right. That's the beauty of it. But,
right. Okay. So I think it may behoove us, I think probably at the full task force
to get started,
to do that. So.
Or at least get started, and we can have some volunteers take it on for a little bit, but at least to scope the initial issues.
Do you have any suggestions? Anybody have a suggestion? Maybe you know somebody or something? If not, then I can sure.
Member Moss?
Maybe somebody from where he works at EFF. I mean, maybe he himself could do it also. If that's his bailiwick. That would be.
We'll find out.
I'm okay with that. I can ask him. All right. Anything else? That's all I got.
Okay.
That's all I got.
Can we take on the next item, adjournment?
Is there any motion to adjourn the meeting?
So,
No.
go ahead.
So moved.
Second.
Thanks. Thanks.